Hello, my name is Bill Galic, and I'll be walking you through this brief history of child welfare in the United States. I have been a professor on an adjunct basis and also as an assistant professor with the University of Alaska, and more specifically in recent years with the School of Social Work for something over 30 years. I also have a career in social work primarily focused upon working with children and families that exceeded 40 years overall. And so based upon that, I have some information I'd like to share with you regarding child welfare history in the United States. I believe it's very important to recognize that child welfare policy is intimately intermingled in general social welfare policy in the United States. And so much of this discussion will also give you some context for the situation within our nation that has molded the child welfare policy that has emerged over the years. Likewise, the social welfare policy of our nation cannot be separated from the political atmosphere in the nation as well. And so there will be some discussion of this as well. Children have been central to the development of welfare programs in the United States throughout its history. Indeed, sympathy for the poor and neglected children has been crucial in breaking through the free market individualism that has been mobilized repeatedly to condemn public aid to the poor and to needy children. Over and over again, poverty has been diagnosed as the product of individual immoral behavior and character. It's even been legitimated as a punishment for immorality, and so it is often removed from the arena of public policy by conservatives in government. A distinction between the deserving and undeserving poor developed very early on in the establishment of social welfare policy in the Western world, and there's a fear that aid to those needy individuals might encourage immorality, and this underlays the policy of both charity and local government relief programs. The notion of the innocence of children, though, as opposed to their caretaker, has worked to modify this harsh refusal when it comes to working with kids. Until the early 20th century, provisions for needy children were primarily local and private, but gradually these provisions have moved to being the responsibility of government on a state and national level. And there is a constant tension in policymakers as to where the concern should be placed and where the responsibility should be placed for tending to the needy, both adults and children. The underpinnings of our social welfare philosophies include some basic concepts such as Judeo-Christian teachings, which focuses upon charity and the provision of relief for the poor. The feudal system also has a lot to do with how our system has developed. In this economic system during the Middle Ages, lords developed protective caretaking roles over the serfs that lived outside their manor, and the serfs in exchange would provide food and other items to the individuals living within the castle. So there was sort of a mutual aid society there. With the introduction of the cash economy in Europe, the feudal system collapsed and the serfs wound up roaming around Europe looking for places to live and for ways to earn a living. These individuals came to be known as vagabonds. The English poor laws developed in the early 1600s as a means of specifying how to deal with these poor persons. It spelled out responsibility for tending to the needy through such things as very early taxes. It established restrictions on who could receive care, and so, for instance, some of the earliest forms of residency requirements were established then, saying that if an individual didn't live in the community wouldn't take responsibility for tending to their needs. Also, warning out became a system that the communities used in order to deal with individuals who wouldn't leave the community, basically saying you have a certain amount of time to get out of town. We began to differentiate between the worthy and the unworthy poor. Now, I'm not suggesting that this is a legitimate differentiation, but it is one that occurs in any discussions regarding poverty and assistance for the needy. American colonial laws developed from this and reflected the Elizabethan welfare system. And in the early colonial days, parish and town councils were responsible for residents. There remains a constant debate about whether government is responsible for any social welfare programming, as we'll see during this discussion, and if so, which government should it be? One system that began to develop in the 1700s in the United States was the system of almshouses. We refer to this as indoor relief in that individuals would be provided with care inside of a building, essentially. Residency requirements were included as a part of being eligible for almshouse care. And again, communities used warning out in order to manage the number of individuals they had in their responsibility. Communities that weren't able to fund almshouses actually began to auction off the poor, apprenticing out the children of the poor as a way of dealing with these individuals. By the end of the colonial period, the responsibility for the poor began to shift from the towns to the larger colony and eventually to the state. And concern began to grow that children shouldn't be housed with adults in these communal facilities. It's important to realize that a lot of the concern about children had to do with their economic productivity. That is, would they be able to be trained to become individuals who would be able to contribute to the economic system in America? And so there was an effort to begin to make sure that they were provided with proper raising and education in this area. And so at times would be removed from families with parents who were destitute and not providing contributions to the economic system. This is a point that will be reflected in the way we treat children throughout our history, even into the modern day. By the end of the 18th century, able-bodied unemployed adults were not provided care without having to provide work back, and so they were placed in what was known as workhouses rather than almshouses. And by the early 19th century, the workhouses became their primary mode of assistance for adults. There was some advocacy for improved services for some of the poor and those who were in need. Dorothea Dix advocated for improved services for the mentally ill, and she won congressional approval for funding services to the mentally ill. But Franklin Pierce, who was president at the time, vetoed the federal government's involvement, believing that the government did not have a role in tending to the social welfare needs of its citizens. This continued really to be the philosophy of the federal government until the time of the New Deal after the Great Depression in the 1930s. In the mid-1800s, the federal government began to acknowledge limited responsibility for the poor and needy, though. For instance, veterans' assistance, particularly following the Civil War, which compensated soldiers for the sacrifices made to the Civil War. The state of Mississippi, in fact, devoted over half of its budget following the Civil War for replacing limbs of its veterans. The Freedmen's Bureau was established to assist the freed slaves in establishing themselves in a new economy where slavery was no longer dominant, and this bureau was dissolved by Congress in 1872, just a few years after the end of the Civil War. And this left African Americans largely without any kind of assistance from government or any agencies for that matter, except mutual aid societies. And they were left to tend to themselves well into the 20th century. Science became very popular in the 1800s, and with the advances of science, an interest in the scientific method was growing, and there was an attempt to apply the scientific method to understanding human beings and their behaviors, and also to understand poverty and how to overcome poverty. And a philosophy of social Darwinism developed, which essentially said that if the competition for scarce resources is nature's law, then the poor suffer because they can't compete. And the wealthy were entitled to their spoils, this belief goes, because of their fitness, their economic fitness. So aiding the poor and coincidentally allowing their reproduction altered the laws of nature and weakened the human gene pool. And so aiding the needy was seen as thwarting the evolutionary progress of humankind. Another value that took root during this period of time was the Protestant work ethic. Religious institutions provided a lot of the relief for the poor, and they reinforced the Calvinistic notion that work was a moral responsibility. And so this work ethic developed from this central value in our society. Poverty was seen as a moral failure, and work was a duty of God-fearing persons. And so therefore individuals who were economically destitute were seen as immoral. And those who were doing well economically were seen to be existing in God's favor. So this work-oriented society became promoted, and neglecting the poor was seen as actually having religious backing during this period of time. And very much so today, this notion of work as the means to redemption is still practiced in our society. You see the work requirements, for instance, that are tied to the public assistance programs that exist today through the temporary assistance for needy families, food stamps, or SNAP programs, and so on. Early social work involved mostly untrained, volunteer, and mostly middle and upper class women who were connected to a church. So they had the belief, and they preached the belief, that the poor have to be taught to live moral lives. Poverty had to do with living immorally, given that work was a moral thing. So intervention focused upon spiritual guidance, and if any cash aid was given at all, it was tied to the demands such as abstinence from alcohol. But generally speaking, these early workers did not believe in providing cash relief, which incidentally was known as outdoor relief as opposed to indoor relief. In 1870, charity organization societies began, and these societies coordinating relief that were provided by the various agencies. There was a lot of duplication of services going on, and also there was concern about a fair amount of fraud occurring within those organizations. And so the COS was intended to oversee these efforts. And the Friendly Visitor, which is an early forerunner of social workers, conducted investigation into the client's life and instructed the poor in ways to better manage their lives. Beneficent charity was seen as counterproductive, contributing to dependency and laziness. Again, this means providing cash assistance largely. It was intended that something had to be given back in order to get the assistance that was needed from these organizations. Interestingly, although they didn't believe and advance the notion of providing cash assistance, they provided some of the earliest forms of social research about poverty that established that poverty really had more to do with the system and not with the individual and the individual's faults. A movement called the Child Savers developed during this period of time, and the Children's Aid Society, which continues to exist today, coincidentally, was a part of this child-saving movement, and its early efforts was involved in sending orphans to the West by train and placing them with farm families when they needed the extra free labor. We'll talk about this in a few moments. In fact, here it is. One alternative to almshouses that developed, including apprenticing children to local craftsmen and artisans for care. When parents weren't providing economic contributions to society, their children were oftentimes removed from their family and placed with individuals who could teach them how to be economically fit for society. Again, that focus upon making them able to contribute to the economy. In this capitalist society, the economy is key to so much of what we are able to provide to individuals who are in need. Another alternative developed as well as the nation expanded westward. And so from the mid-1800s almost to the mid-1900s, some 200,000 orphaned or abandoned children from eastern cities were put on trains and sent west to join new families in other parts of the country. And this was something that provided free labor to assist those who were establishing farms in the West, as well as providing them with care and proper instruction in making their own way in the world. Children's Aid Society in New York hoped that these children would benefit from living in family homes where they'd receive good education and training in wholesome work. And this was really the apprentice programs, and the orphan trains, as they were known, were early forerunners of the concept of foster home care that we know today. From time to time, we're going to take a look at how our minorities, and perhaps most particularly the Alaska Native and Native Americans, have been treated and seen during the development of our social welfare and child welfare programs. For the American Indian and Alaska Native population, colonialism reduced the indigenous population in the Americas from an estimated 60 million, perhaps more, at the time of the first contact with Europeans, to about 6 million by 1600, a little more than 100 years. By 1900, only 300,000 Native Americans were identified in the United States. And this reduction in the population has to do with the violence that's well documented in our history, as well as disease and famine that occurred as a result of the expansion of Europeans into the Americas. About 90% of the American Indian and Alaska Native population was wiped out in this process. During the early years of the Spaniards' involvement in America, Spaniards would seek permission from the Catholic Church to punish the Native Americans for their sins through such activities as rape. They were considered deserving of punishment because they were savage, evil, and rebellious in the minds of the Christian Spaniards. After 1775, a bounty paid American colonists for every Native American scalp that was handed over to white authorities, and it was equated to about $7,300 for each murdered person in today's dollars. And the intent here was, of course, to clear out the land for the European settlers. Under Andrew Jackson, the Indian Removal Act of 1830 led to the deaths of over 100,000 Native Americans as the tribes were physically marched from the south and east to much less arable and harsher lands to the west, to allow for cotton growing and other industries to be established by the white settlers in the more profitable lands in the east and south. This was the famous Trail of Tears that you've heard about. If you ever hear a social worker talk about the profession, one of the favorite stories that social workers will tell out there in the community is about the famous Mary Ellen case. This occurred in Hell's Kitchen in New York City, where a missionary was determined to rescue this little girl from one of the city's worst tenements. She found this little girl tied to or chained to a bed, I believe, and being left alone, and was very emaciated and malnourished, but found that there were no laws that enabled her to take that child to a safer environment. Interestingly, there was the American Society for the Prevention of Cruelty to Animals during this time, even if children were not yet protected. So the famous story goes that Mary Ellen was taken into court under the laws that protected animals, and that's not really true. That's sort of the mythical part of this story. But the missionary did appeal to individuals within the ASPCA to help her determine how to approach the court in order to remove Mary from these guardians. This actually set in motion events that led to the creation of the New York Society for the Prevention of Cruelty to Children in 1875, the first organization that was solely dedicated to protection of children. It's interesting that we were protecting animals before we were protecting children. The first juvenile court was established in 1899, and this arose from the growing recognition that children were different from adults and needed different treatment. This occurred in Chicago. I believe Jane Addams had a lot to do with the establishment of this first court, and it led for the way for other juvenile courts to be established around the nation. So within 20 years or so, all but 3 of the states in the United States had juvenile courts. In 1912, the Children's Bureau was established, and this was the first federal agency that was devoted exclusively to improving the lives of children and families. A little bit about the settlement house movement. We talked about the COS and the casework that was provided by the friendly visitors that focused upon individual change, individual fault, and morality. The settlement house movement was very different in that it really appealed to the strengths of the individuals that they were working with, not the weaknesses of the individual. Largely wealthy and upper middle class women moved into the hearts of the cities, into the poor neighborhoods, and established homes where the local residents could come and pick up skills. Oftentimes these individuals were immigrants, and so there was a lot of English teaching going on so that the immigrants had command of the language. Provided recreation and education for the children and many other kinds of things. It also focused upon organizing these individuals to appeal for a change in conditions that was negatively affecting them. And so this really was an effort, rather than focusing upon changing the individual, placed upon changing society, changing the system. And so this was more of a macro approach to social change. The most famous of the settlement houses was Hull House, which was established in 1889. Jane Addams was one of the individuals that founded Hull House. She was not the only one. And some individuals that became head of the Children's Bureau eventually also were Hull House alumni. While these institutions challenged the notion of individual fault for adults who were destitute by focusing upon systemic reforms and not casework, many of these were not without fault. And there's belief these days, it's been noted that many of these settlement houses refused entry to African Americans or set up settlement houses in African American neighborhoods to serve them separate from the white settlers. So despite Jane Addams' support for racial equality, Hull House was itself segregated into the 1930s, well after the neighborhood's African American population had increased. Now, there has been some revision in the telling of this story and the references. I've actually listed a couple of articles you might look at about this. There's some idea that perhaps this notion that Hull House was forcibly segregated is perhaps overstated. But during this period of time, African American associations had to take care of the service needs because there was just no government interventions providing for the needs of African Americans. Fraternal organizations and mutual aid societies provided for the needs of this population. And black settlement houses were established to assist during the Great Migration as many blacks moved from the South to the North to seek work in the early 20th century. Oftentimes, factory owners and producers would use those individuals moving up from the South as strikebreakers when whites were advocating for better working conditions, and this created a lot of resentment among white workers against those blacks who were moving in and taking their jobs. Also, individual black colleges and universities began to develop to serve rural African Americans. And social reform organizations such as the Niagara Movement and the Urban League began to develop during this period of time as well. But still, even the social work profession as a whole continued to ignore the needs of African Americans. As for Native Americans, the Dawes Act of 1887 regulated the land rights on tribal territories within the United States and subdivided Native American tribal community land holdings into allotments for Native American heads of families and individuals. Now, the Native American culture did not assume this proprietary relationship with their property. It was a much more of a communal kind of a culture. And so here the federal government really was forcing Native Americans to assume this more capitalistic idea of owning a piece of land. But before private property would be dispensed, the government had to determine which Indians were eligible for allotments, and this propelled them to begin to identify ways to develop a federal definition of what it meant to be an Indian. Only Native Americans who accepted land under this act were allowed to become U.S. citizens at this time. Eventually, in the 1920s, Native Americans were given citizenship, which again is an ironic thing given that they were here before we were. Any lands that remained after the allotment were declared to be surplus and made available for sale, including to many non-natives. And it was estimated that about 2/3 of the Native American lands was lost to white settlers because of the Dawes Act. The federal government and the Bureau of Indian Affairs realized that they couldn't remove Native American persons from the country, and so they adopted a policy of assimilation. This Dawes Act was one example of that, forcing the idea of property rights onto Native Americans. But also in the last few decades of the 1800s, boarding schools began to become established around the United States. Some of the earliest ones were the Hampton Institute and the Carlisle Indian Boarding School. This was intended to civilize young Native American persons into Christian values and Protestant work ethics. The motto was by one of the leaders of this movement was to kill the Indian and save the man. At the same time, Christian missionaries were populating Alaska in the southeast and throughout the interior as well. Different churches were doing that, and there were efforts then also to Christianize and save the Native Alaskans from their pagan religions, what was seen as pagan religions, I should say. Boarding homes were established around the United States and in Alaska, and parents were often coerced into placing their children in these homes, whether they wanted to or not, were threatened with imprisonment if they didn't, and when the children were placed in boarding homes, often weren't allowed to visit their kids. So you can see, here's a very early effort to remove Indian children from their families and from their culture. The first boarding school established by Americans in Alaska occurred in Sitka in 1878 by Presbyterian missionaries. Over the decades to follow, boarding schools were opened across Alaska, again usually operated by Christian missionaries. And around the turn of the 20th century, many of these schools were taken over by the federal government. Kids in these schools were often punished for practicing their religion, for speaking their own language, for using their birth names, for wearing long hair, those types of things. And this occurred even in the boarding schools within Alaska well into the 20th century. Many Alaskan natives, though, were sent outside of Alaska to Indian residential schools, such as the Carlisle Indian Industrial School. Overall, there was a developing awareness of the needs of children in the late 1800s and early 1900s in the United States. This was due to the recognition of children as needing special care. They were no longer seen as miniature adults. I like to show this drawing of Sir Walter Raleigh and his son from somewhere in, the 1600s perhaps. And you can see here that his boy is presented as a little adult. He really doesn't show any signs of being a child or anything different from the adult. And that's oftentimes how children were viewed in the earlier years in our Western culture. But by the 1900s, earlier than that, actually the 1800s, as the movement for child saving began to be recognized, that we were seeing children as having more special needs. In 1904, G. Stanley Hall, famous psychologist, published the 2 or 3 volume work called Adolescence, which established the teen years as a stage separate from adulthood as well. And so we actually began to see teenagers as having separate needs as well. So juvenile courts began to be established, and the doctrine of in loco parentis also was established. This was a policy that essentially gave the judge the right to act as a parent. That's what the Latin term means essentially. And while this was a well-intended doctrine, nonetheless, it was a problem for children in that it gave judges the rights to remove freedom from the children in order to protect them from themselves for as long as the judge wanted to, right up until the 21st birthday to adulthood. And so it didn't matter what the crime might have been, or even if there was a crime, the judge could incarcerate, essentially institutionalize the child for years and years and years. Child labor laws also began to be established during this period of time rather slowly, but it was occurring. And also mandatory education became a thing as well during this period of time. This improves the treatment of children, perhaps, but again, a lot of sociologists would tell you that the primary motivation for much of this had to do with economic benefits to society. During this period of time, there were several depressions and recessions, and employment became an issue. And so removing children from the labor market, forcing them into schools, really was a way to free up the job market and to create more positions for men. And again, this is an era when women were, although they were heavily employed now, were still not seen as the primary source of income. And so the focus was upon creating employment opportunities for males, adult males. In 1909, further recognition of the special needs of children, the first White House Conference on Children and Youth was held in Washington, brought together leaders in the study of children's issues to talk about the negative effects of institutionalized care for dependent and neglected children. So they're looking at getting kids out of group facilities now. And some of the proposals included acknowledging the importance of keeping children in their own homes. There's a novel concept for this period of time. Called for family foster care if kids could not be in their own homes, advocated for state oversight of foster homes that did exist at adoption agencies, and also endorsed the creation of the Federal Children's Bureau, which I think I had mentioned earlier. During this period of time, there was also a movement to establish a widow's pension to help them provide for the children, and there was an early effort to establish a basic family income, although that didn't really take roots during this period of time. Focus was, at this point, upon trying to keep kids with their families. The Keeling Owens Act passed in 1916, and this was the first child labor law, essentially. And what it did was it used the Department of Commerce's rules about interstate commerce and said that it was illegal to purchase products produced by children under the age of 14, any of those products that were taken across state lines. This law was struck down by the Supreme Court in 1918, but not before the Bureau staff helped state officials inspect working conditions in approximately 700 factories and mines. This law was eventually reestablished by Congress and became a national child labor law. But before child labor laws were enacted, many factories employed kids under very dangerous conditions. The Great Depression occurs in the early 1930s, and Herbert Hoover was voted out of office. Franklin Roosevelt came in promising to rescue America, more or less, and through a series of his proposals, eventually in 1935, the New Deal emerges, and the Social Security Act is a part of the New Deal. And there are three primary parts of the Social Security Act, and each of those parts had something that impacted the welfare of children. First, survivors' benefits for spouses and children was added to the federal social insurance for workers in 1939. So if a worker died, then their spouse and children would have a pension from the federal government. In Category 2, the Aid to Dependent Children program was developed, which was originally intended actually to allow mothers to stay at home with their children. Think about this and how in a time of a tight labor market following the Depression, there's an economic benefit to working males to keep women out of the workplace during the Depression. So again, although there are efforts to help families and help children, there's an economic underpinning to those efforts. But this program was eventually put under the jurisdiction of the Department of Labor, and instead of focusing upon the needs of children and children needing their mothers to be there to raise them, the focus became placed upon the unemployed parent. And finally, maternal and child welfare included services to children with disabilities and chronic medical and health conditions, and also introduced child welfare as a focus for the federal government with programs for neglected children. This is the early forerunner of child protection. The Aid to Dependent Children program was originally authorized only to provide assistance to suitable homes with children in the first 3 decades, and this was used to reduce the number of eligible children. In 1960, 79 of every 1,000 children were in need, but only 30 received assistance. In the 1950s, the caretaker was added to the grant, and so ADC became AFDC, Aid to Families with Dependent Children. And this further increased the focus of the public upon the unemployed parent rather than the needs of the children. Public assistance workers, who were, again, primarily white middle-class females, reflecting the early social workers in the 1800s, they were administering payments under the AFDC program and would make home visits to document the parents' eligibility. Now, there was not allowed to be a man in the home in the early days of this program, really throughout most of this program. And so those workers would often truly rummage through closets and dresser drawers looking for evidence of a man being in the home, even if the man wasn't there during the home visit. Cigarette butts, shoes, men's clothing, those kinds of things all were used as evidence that the woman was living an unfit life, and they could deny payments and actually remove children if they deemed the parent to be unfit as proper guardians. Sometimes the workers would conduct midnight raids to ensure single mothers did not have any illicit relationships going on. Actually, this was continuing even into the 1980s. There was a suit by social workers in the state of California to challenge the state from their requirement to provide these late-night raids in welfare clients' homes. In the mid-1970s, with the revision of the Social Security Act, the provision of social services were separated from the administration of payments, and so those AFDC workers no longer had the authority really to make any removals of children and such. In the early 1960s, it wasn't particularly a good time for children. Louisiana dropped 23,000 children from its welfare rolls in 1960 because their parents weren't married when children were born. The Health, Education, and Welfare Department established the Fleming Rule, which required the states to provide for children even if they were determined to be living in unsuitable households. But this reflects the moral judgments that were continuing to be tied to the unemployed parent here. In 1961, the Social Security Act expanded to include funding for foster care for children in AFDC families, and this was required in all states by 1969. A seminal work in 1962, The Battered Child Syndrome, was published by Ray Helfer and Henry Kemp, which began the movement to establish child abuse protections across the United States. By 1965, child protection services were required in all states by the federal government, and mandatory reporting laws existed in all states by 1967. The Helfer and Company realized that doctors were seeing children with broken bones repeatedly and with signs of previous injuries when they did x-rays, but not reporting the obvious abuse that was going on for fear of being sued for malpractice. And so the original child protection reporting laws focused upon medical personnel and required them to report suspected abuse to the authorities. However, eventually this expanded to include virtually anyone in Alaska. Anyone who comes into contact with children as a part of their work are mandatory reporters. And in many states, everyone is a mandated reporter, even your next door neighbor. 1964, Lyndon Johnson declared a war on poverty, and this was significant really in working to reduce poverty. Between 1961 and 67, there was a 50% increase in the number of children receiving child welfare services in any month. At the same time, children in foster care, the composition of kids in foster care changed as well. Because of these enhanced economic supports, fewer families were breaking up due to poverty alone. And so, as a result, a larger percentage of children entering foster care did so for reasons that caused greater emotional disturbance, such as abuse and neglect, parental instability, and substance abuse. And this led to the placement of children with more problems and more disturbances in homes, and sometimes kids in foster care became very difficult to care for. Now, it's important to note that in Alaska, and I believe in most states, child welfare policy, child protection policy specifically states that children are not removed from the homes because of poverty. Another advance on behalf of children occurred in 1967 when the Supreme Court ruled in the GOLT case that children should have the same rights in court proceedings that would apply to adults. So their sentences had to be of similar length for a similar crime, for instance. And so this modified and restricted the in loco parentis motivation of juvenile court judges, and kids were no longer allowed to be held until their adult years for minor infractions of the law. But really the punishment and consequences for these infractions had to be corollary to what was going on for an adult with a similar kind of infraction. Doesn't mean to say that in loco parentis no longer exists in the minds of juvenile court judges, but it's really much more restricted than it was in the early 1900s. As much as a half to a third of all Native American children were separated from their families, and about 90% were placed in non-Native foster homes, adoptive homes, or institutions by the mid-1970s. Now, this is a concern again because this is robbing children not only of their families, but in many cases also the opportunity to grow up in their own culture. And today, a disproportionate number of Native American children are placed in foster care still. 2% of U.S. children are American Indian or Alaska Native, but they represent over 8% of children in foster care. So the Indian Child Welfare Act was established in 1978, and it's a federal law that protects the best interests of Indian children and to promote the stability and security of Indian tribes and families. You're going to have a section later on in this course that will look at this much more closely, but just as a brief overview. ICWA requires Child Protective Services to actively involve the tribes when providing intervention and services to Native American children and their families. If the tribe elects not to be involved in the case, Protective Services workers should be talking with the tribe about the reasons why they should be involved. Congress passed the ICWA laws in response to the high rates of separation of Native American families with the goal of preserving those families and that culture. But still, during a study from 2006 to 2013, it was found by the Institute of Social and Economic Research at UAA that about 2,000 Alaskan children were in foster care in any month, and 60% of those children in foster care in Alaska were Alaska Native. Now, Alaska Native children make up less than 20% of the population in general, but were 60% of the children in foster care. So this reflects a disproportionate representation among foster care. And there's a question as to why that is, and we'll touch on this before we finish this discussion. Alaska Native children are 7 times more likely to be in foster care than white children. ICWA requires that relatives of the Indian child be notified within 30 days of any child's placement in foster care, but really requires that initial efforts be made to place the child in an appropriate placement that is culturally connected. First, that would be with a relative. Secondly, with a family of the child's own tribe. Thirdly, with another Native American Indian home, and so on. And if children are placed in homes that are not culturally appropriate, then the worker has to continue their active efforts to find an appropriate cultural placement for them. Also, as opposed to reasonable efforts, which is something I haven't touched on yet, but I will in a few moments, ICWA requires a higher standard of efforts by the courts and child protection workers to preserve Native American families and culture, called active efforts. You'll learn more about that later in this course. So what about disproportionality? We were talking about the high number of Native children in foster care in Alaska. It occurs in many areas where services are provided, not just foster care, but also in areas such as mental health and health care as well. But families of color are disproportionately represented in the child welfare system, not only in placement, but in all phases of the child welfare process. And they're more likely to experience negative outcomes compared to the white families that are engaged in the same system. While African American children experience the highest rates of disproportionality in foster care in the lower 48 states, in Alaska, disproportionality is most dramatically reflected in the placements of Native Alaskan children in out-of-home care. As I mentioned earlier, over 60% of kids in foster care are Alaska Native, although they represent less than 20% of the child population in Alaska. So there's been a lot of efforts to determine what causes disproportionality. Is it related to faulty assumptions and reasoning by workers? Are the workers applying standards from the dominant culture that don't necessarily apply in Native cultures, don't represent risk of harm to children? Does it reflect some racism among workers and among policy workers? Is it connected to social and economic factors in a larger sense? Does it relate to deficiencies in system policies and practices? These are things that are the subject of study when we look at disproportionality. The Annie E. Casey Foundation Child Welfare Strategy Group said that disparities in child welfare placements like foster care are strongly influenced by decisions made earlier. In child welfare, the largest disparity by race is usually at the system's front door. That often means when families first come in contact with the system, when children are reported to agencies for neglect or abuse. So the entry into the system is the common place to find disparities in decision-making about children of different races or different ethnicities, so it snowballs from there. Now, that's not to say that's the only reason for disproportionality, but it is one place to look at from the very beginning, from the time that report is taken. So a key to understand the question at the heart of all child welfare analytics: how are our children faring when they come into contact with our child welfare system, and what can be done to improve their experience? Studying disproportionality and attempting to remediate that is something that is one way of doing this. And again, this is something I'm sure you'll be hearing more of. Back to our social progress analysis. Here you see in the 1960s, a lot of social progress was being made in the terms of human rights with the Civil Rights Act, Voting Rights Act, Medicare and Medicaid established, which really was one of the largest contributors to the reduction in poverty, particularly among the elderly population in the United States. Food stamp program, now the SNAP program, began in the 60s. It is still once again, it's a program of the Department of Agriculture and was intended to help farmers deal with their surplus foods. It does feed individuals who might not have access to these foods otherwise, but remember, it's also benefiting the farmers, the people who truck that food to the market, to supermarkets, and individuals who work in those supermarkets. It's an economic benefit, not just a public welfare program. Other kinds of federal acts here, you see the Mental Health Act. ICWA was established in the 1970s. Indian Civil Rights Act, which 68, which gave tribal members the rights to a jury trial, to assemble, and to petition as well. And there were some Supreme Court decisions that profoundly affected human rights, including the Miranda decision, which I'm sure you're familiar with, the GOLT decision that I had just spoken about, Loving versus Virginia, which overturned state laws that prohibited interracial marriages, and Roe versus Wade, of course, the abortion decision. All were from this late 1960s to early 1970s era. But this was followed by an era of social retreat under Richard Nixon and continuing at least through Ronald Reagan. So Nixon actually proposed a basic family income program. He was more liberal than he gets credit for. The Family Assistance Plan was defeated by Congress, though. But there were some changes in the Social Security Act that essentially developed the Supplemental Security Income Program, or SSI program, which is sort of a modification of this program. Reagan subscribed to trickle-down theories of economics that, that's the idea that if you put money in the hands of the wealthy, the benefits will trickle down to the workers and to the poor person. Over and over again, this has been proven not to be effective, but nonetheless, conservative leaders continue to utilize this approach with tax cuts to the wealthy. The moral majority became politically powerful during this period of time and had a lot of influence upon the leadership with its conservative cultural ideas and beliefs. And as a result of this, homelessness increased, real income fell, industrial jobs were lost and replaced by low-wage service industry jobs. Industry jobs often were unionized and paid higher wages. Service industry oftentimes is not unionized and doesn't even pay a living wage in most cases. Skipping ahead to the Bill Clinton era, the Welfare Reform, Personal Responsibility and Work Opportunity Act of 1996 altered the AFDC program, replaced it with the Temporary Assistance for Needy Families program, TANF, and this attached lifestyle demands, again, moral judgments, to provision of assistance, put lifetime limits on how long assistance could be received. There was a serious attempt to pass a healthcare reform and to establish a national health insurance program in the early years of the Clinton administration. Hillary Clinton, the First Lady, led that effort, and it failed in 1993 with intense lobbying from the AMA and the healthcare industry in general. There was an attempt to have national health insurance in the Social Security program, in fact, in the 1930s, and the AMA lobbied against it at that time as well. Republicans took control of both houses of Congress in the mid-90s, and the House proposed the Contract with America, which was a restrictive and punitive effort to reform and punish poor people, particularly those receiving public benefits. And I'll tell you in a moment how that translated to services to children. And also the infamous Don't Ask, Don't Tell and Defense of Marriage Acts policies were signed into law by President Clinton under pressure from Congress, who threatened to actually propose a constitutional amendment to define marriage as being between a man and a woman. So this also had a negative impact upon the LGBTQ population. So all of this has something to do with child welfare, I was saying earlier. And here are some efforts from this era in programs for children that, just to run through these briefly, handicapped children early intervention programs began to be established in the early 1970s, and developmentally disabled have continued to get more and more legislation to assure them equal access in our society, both children and adults. CAPTA, the Child Abuse Prevention and Treatment Act, was established in the mid-70s to address child abuse and neglect, and first mentioned reasonable efforts. That means essentially that workers have to provide some efforts to prevent the removal of children, or if the children are removed, to continue to work with parents to reunify these children with their family so that they can go back home again. Reasonable efforts. What happened with reasonable efforts, at least according to one version of the story that I have read, is that the workers were so focused upon providing reasonable efforts that children remained in foster care for years and years and years, particularly with substance abusing parents where relapse occurs and maybe children have to be removed again because they're endangered in the homes of their parents. And so children could wind up languishing in foster care for years, and we know that's not good for kids living in temporary homes over the years. And so the feds established eventually some limits upon that, and I'll touch on that in a moment. ICWA was established in 1978. There were more programs for federal funding for foster care and adoption and for independent living programs to help transition older children out of foster care. This has also continued to have a number of modifications and enhancements over the years. In 1993, there was funding authorized to help preserve, support, and reunify families in crisis through the Family Preservation and Support Services Act. That reflects the focus upon reasonable efforts to keep families together. In 1994, the Multi-Ethnic Placement Act, or MEPA, was also established that prohibits the delay or denial of a child's adoptive placement solely on the basis of the child or adoptive parents' race, and requires diligent efforts to recruit and retain foster and adoptive families that reflect the racial and ethnic diversity of the children for whom homes are needed. So in other words, couldn't deny placements to children because of race or to families because of race as the sole reason for that denial. But the states nonetheless continue to be obligated to try to recruit homes so that children could be placed in families of their own race or ethnic group when possible. I already mentioned the contract with America in 1994 during this very conservative legislative era. One proposal by House Speaker Newt Gingrich was, and this got a lot of attention, was instead of paying parents to provide for their kids in the home through welfare programs, through food stamps, put the kids in orphanages. That's an attitude from the early 1800s, in fact. Welfare reform in 1996, as I just got done mentioning, the Adoption and Safe Families Act established child safety as a top guideline in child welfare and established guidelines for permanency for children in out-of-home placements. So here we're looking at the effects of reasonable effort after reasonable effort after reasonable effort, and now the federal government is saying, wait, you have to establish a permanent plan for children so that they know where they're going to be in the years ahead, not just continuing to stay in temporary foster homes. And so out of this came the concept of concurrent planning, where as a treatment plan is established for a parent when children are removed, a concurrent plan is also established for the child that would establish permanence if that parent doesn't achieve the goals in their treatment plan within a reasonable period of time. And that's all been defined by the federal government. And again, you'll talk about that later in this course. I'm not going to go into specifics of that. But there are time limits for parents when kids are in care. In 2001, the Child and Family Services reviews began, and this is where the feds come out to go around to all the states and review their child protection programs and assess a number of different things for whether they're providing for safety, permanency, and well-being for the children and families in their system. And this happens every so many years and always gets a lot of attention. States almost always fail because the feds set high bars to encourage the states to do better. There are also some advances in terms of children who were victims of sex offenders with the establishment of sex offender registries under Megan's Law and the Prevent Sex Trafficking and Strengthening Families Act of 2014. And also in 2018, the Family First Prevention Services Act permits states and eligible tribes to receive federal reimbursement from Title IV-E to support family preservation services. The tribes have gained a good deal of authority in many areas in child welfare, and it's something that I know you'll be talking about more as the semester goes along. A couple other quick things. Under Trump administration, there really was an effort to scrap or undermine the ACA, the Affordable Care Act, throughout that administration. Judges that were appointed to the federal courts and the Supreme Court were all quite conservative. And this may have an impact upon the human rights advances that the courts established in the 1960s and 70s as time goes on. It was very supportive of the state's efforts to restrict or complicate access to abortion under Roe, and on and on and on, as I'm sure you're aware. Just as the Trump administration tried to roll back a lot of the Obama administration's programs, Biden administration early efforts have been to roll back a lot of the Trump's rollbacks as well. And there's been a focus in the Biden administration really on establishing more support for families through increasing food stamp benefits and child tax credit, for instance, more child care grants and those kinds of things. And he's encouraging, this is still hung up in Congress, an effort for universal preschool, direct support to families and workers, extended tax cuts, improved paid family leave, and those kinds of things. Looking to the future and closing this discussion, I want to point out that in the last several decades, child welfare policy has veered between two goals that are often in conflict with each other. That is child protection, safety, child safety, and family preservation, that is keeping families together. CPS agencies struggle to find the balance between these two goals and are expected to do both, really, and often fail to satisfy advocates of both of them. Overall, the United States has a very poor child welfare record in general and are reflected, for one thing, in the fact that our child poverty rate is the highest of any nation in the developed world, as much as 5 times higher than the Scandinavian countries. So families who enter the child welfare system are often facing hardships that are caused by a host of social and economic factors, many created and promoted through systemic racism, and these factors complicate and challenge a parent's ability to care for their kids. Poor families, and most particularly Black, Latinx, and Native American families, come to the attention of child welfare agencies in large part due to the prolonged unmet needs that result from racism, from poverty, and other inequities in the system. One movement called Upend seeks to radically shift how we view the safety and protection of children by imagining a society in which the forcible separation of children from their families is no longer an acceptable solution for families in need. Ultimately, they're advocating for the abolition of foster care and the child welfare system as we know it. Its philosophy is rooted in the notion that the safety and protection of children should rest with families and communities first of all, because the separation of children from their families is rooted in racism that can cause even more trauma and even more harm. The conflict of goals I mentioned a few moments ago, that is, between child protection and family preservation, is evident in the abolition movement. From the very point of first contact, should children be removed to assure their safety, or should services be provided to families to guarantee that safety can be provided and a family can be preserved? If children are removed, should reasonable and active efforts be utilized over and over again to ensure that children can be reunified? Or should there be a permanent plan for children that guarantees that kids don't stay in out-of-home care forever? What efforts are being made to unify children with relatives, for instance, if they have to be removed from the family to begin with? And in fact, the whole idea, I think, is for families to intervene in order to protect the kids rather than the state needing to intervene to do so. These are things that are being mulled about in this movement, and it's something that you'll hear more about if you stay involved in child protection issues over the years. In moving towards the abolition of foster care and the child welfare system, the Upend movement will actively work to advocate for the creation and expansion of critical safety net programs that are necessary for families in order to prevent harm to kids, to increase the availability of safe and affordable housing, to support the expansion of informal kinship care outside of the child welfare system, and increase concrete supports to families to care for the kids without child welfare intervention. This, again, involves a whole retooling of the social welfare system to look at issues about poverty and mental health and substance abuse and all those kinds of problems that intrude upon a parent's ability to care for their kids. Support the end of congregate care placements for children and youth group homes and large family foster homes. Support the strengthening and greater application of reasonable and active effort standards, and to support the elimination of policies that use arbitrary timelines to terminate parental rights. That's the permanency provisions in current federal statutes. And so you see, it goes back and forth, and everything is being reviewed again and will continue to be reviewed. The child protection system as it exists has a lot of problems in it, and it's good that there is an effort being made to really step back and look at new ways to design child protection from the ground up. And so it'll be interesting to see what happens in the years ahead as we continue to refine and hopefully improve child welfare in the United States. Thank you very much for listening to me. I hope that there was some useful information here. I am available. You can ask your instructor if you have any questions for me. The instructor will know how to contact me. There are also 2 slides here that give you my references and suggested readings that relate to this particular topic if you'd like to explore any of these issues further. Thanks again very much for listening.